we're going to talk about non-competes.
Non-competes, and I teed it up pretty well in the general session.
Yes.
Right, so, but we're really going to dive into then ideas, suggestions, recommendations, options for organizations to consider as we're envisioning a world in which non-competes are going to have a much lesser role and maybe even not a role. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
Okay, so we're going to be talking about a world without non-competes. First of all, Sarah's going to give you a very short update about what the legal landscape is and then what it will mean for your business. And by that we mean non-competes are often used to protect other important interests, right? Like if absent everything else, you're starting with a blank slate. You might not really care where an employee goes to work after they work for you. But you might care if you just sunk 7 years of training into that person, right? Very expensive, specialized training, and then they left. You might care if that person has very important relationships, right? Either with other employees or with your clients, customers, et cetera, and then they leave. And you might care if they have information, right? Proprietary information that gives your business the competitive edge over your competitors, and then they leave to work for a competitor. So oftentimes non-competes have been used as a shortcut. I know, as I've been saying with Sarah, it's like the easy button. I can't remember which business used that in their commercials. But instead of thinking how to protect those three kind of buckets and really working hard at that, you know, we just said, well, let's just say they can't work for any competitor at all, and then we protect all of that. Right? So we're going to talk about that after we give you the legal update, and that's where we're going to spend most of our time, is how do we protect those interests. But first, Sarah, where do we stand?
What the heck is going on, right?
What the heck? My page uses a swear word for that, but that's okay. We're being recorded. What the heck is going on?
Sure. Well, got the overview this morning. We've got the FTC. Essentially, we have two federal agencies now pushing back in telling us that non-competes either are now for non-supervisory employees in the case of the NLRB or in the case of the FTC may very well become unlawful for all workers employed by the employer. And I want to take a step back and just explain a bit more about those FTC rules and make sure everybody understands exactly how broad they are if they are implemented as currently written, Rebecca. The FTC rules declare illegal any non-compete between any worker and any employer.
Okay, can I interrupt you? I don't even know why I ask.
You always do. And you certainly can here, yes.
I was accused in a little room where a bunch of lawyers were hanging out over there of being that kid in the library that is constantly interrupting the kids that are trying to study. That may or may not be true about me. Okay. You use the word worker, right? Normally we use the word employees, right? And laws say employee, employment, et cetera. I know I paused on that when I was reading the rule. Why did they use the word worker instead of employee?
Well, because some clever business folks or attorneys, Rebecca, I'm guessing, might try to get around the rules by calling people independent contractors, I would imagine. And so they've used the word worker, and yes, that word is defined to include both employees and independent contractors and volunteers and everyone else, okay? So they're one step ahead of us there, unfortunately.
So for everyone who said, okay, we'll stop using that non-competes with our employees, but we'll use them with our independent contractors or make some people independent contractors that would otherwise have been employees, that's not going to be a solution for you.
Nope, that's a dead end, at least if we're trying to comply with the FTC rules. And again, importantly to me, this would not only be going forward, but the FTC rules would require us all to go back and actively rescind our current non-competes with our current, quote unquote, workers, okay? You heard Nate talk about the NLRB. Part of it really what I think is most interesting is the state law. And I saw some folks in their responses mention the concern about we have employees working in different states, and this is feeling really terrible and complicated in different states. So how many of you have employees with a non-compete and their primary work location is outside of Michigan? Yep. So more than half of us have employees outside of Michigan, okay? In a way that is almost unpredictable, states are actively passing legislation that are limiting and banning non-competes. And when I say unpredictable, I mean states that we wouldn't otherwise understand to be active regulators for employment laws or issues are banning non-competes, right? So some employers, for example, have made very intentional decisions not to hire people in, say,
California, maybe?
California, right?
I just got a client question for that. So now she had to pay for this email exchange, and you're all getting it for free. Can we say we won't hire people who are working in California? Is there anything discriminatory about that?
There is not.
There is not.
Living and working in California is not a protected class. So anyways, so that's right. So businesses who have devised a strategy maybe to hire people in states that aren't commonly known to be heavy in the regulatory field with regard to employment, that doesn't work with non-competes.
No.
Right? We have non-competes that are completely banned in what I call states in the middle. They never ban anything. It's usually states on either coast, right? Minnesota, North Dakota, Montana, Oklahoma. New York, by the way, is still waiting for the governor to sign it. These are states that say outright you simply cannot have a non-compete. Mm-hmm. But on top of that, we've got more layers of state-by-state restrictions. And again, these are changing by the day, but we've got states that say you can't have a non-compete unless the employee is exempt. Or you can't have a non-compete unless you pay the employee a certain amount of money. Here are examples of those states. There's also a whole lot of states that allow non-competes for certain professions or industries, but not others.
What are some industries, by way of example, Sarah?
So the most common one is healthcare, interestingly, okay? Our own state to our south, Indiana, just banned non-competes for primary health providers this summer and has significant limitations for health specialists, okay? But there's other industries for which they're banned. And then on top of that, there are a number of states that have limits on the terms of a non-compete or have requirements like the Michigan pending legislation saying you got to post it in a conspicuous place in your workplace, or you got to present it before hire, or it can't be more than 10 miles, et cetera, et cetera, et cetera. So this idea that we're going to have some sort of standard non-compete agreement that we're going to have all employees sign is becoming more and more of a pipe dream, because we are in a position in which if you're going to have that complies, that's going to comply with the law of all the states, here's the combined states that have significant restrictions, then it's going to be, number one, very difficult to write the agreement. And by the way, you got to keep up on the legal updates, because you may have a great non-compete that complies with all of the laws of all of those states today, but next week you're going to find out, oops, now we got a new requirement in Kansas. So now we got to update our non-compete, God forbid.
Or you could be in California, others may be following, it's unlawful to even ask an employee to sign a non-compete. So if you're all thinking, well, I'll just have everyone sign, and I'll worry about enforcement later, right? When the person goes to work for a competitor, then I'll figure out what's going on in that state, and I'll call Sarah, Rebecca, or whomever, right? And we'll work it out when we get to enforcement. California, it's unlawful to even ask someone to sign it, and unfortunately or fortunately, depending on your point of view, often others, federal and other states, follow California.
All good points.
All right.
And then, of course, in the states in which they're allowed, and assuming we come up with a non-compete that complies with all of the states in which they're allowed, we got to get a judge to enforce it. It's not been an exception for it to be difficult to do that.
Yep.
We've for a long time, we've had judges that we know simply won't
Right.
enforce a non-compete. It doesn't matter who it's against. It doesn't matter how it's written. Judges don't like them, and they won't enforce them. In some cases, we are seeing more and more and more of that.
So let's talk about then, Sarah, about how we might be, assuming you have non-competes, at least with some of your employees, and maybe the FTC rule does not come into effect, how can you keep it out of court? How can you try to make it enforceable as possible by not letting venue select your judge? There is this concept that some of you may have heard of called an arbitration agreement, right? Some of you are nodding. Some of you may have them in your handbooks or employee agreements. Some may not. There's a lot of pros and cons in general, right, about arbitration agreements for legal disputes, and that's not what you signed up for. But with non-competes and all the other types of agreements we're going to talk about, spoiler alert, we're going to advise you that those should be separate agreements, and you can consider having an arbitration agreement, an arbitration clause, in that separate agreement that applies just to the promises in that. And why might you want to consider doing that? It's not, despite what you might think, time and expense. Arbitration can be just as lengthy and expensive as litigation. It's, first of all, you get to pick your arbitrator. The other side has to agree, but still, right? There's more control than you have in court. And confidentiality, which is really important to a lot of the things we're about to talk about, right? In court, everything is public domain, right? You can go to a court, get on the docket, pull out all the records and documents. Well, that's not helpful to you, right? If you're litigating a trade secret or confidential information or need to show customer list to show the judge what the person stole, et cetera, right? It's very counterproductive. But in arbitration, everything can be kept confidential. So that's something to think about in the other types of agreements, your alternatives to non-competes that we're going to talk about, but also your non-competes to the extent that you still have them or will.
That's really, I mean, to me, that's an excellent point about the confidentiality piece. Yes, you're welcome.
Who thought of that?
I mean, in non-compete litigation, just from the beginning, we may not even want the world to know that our top sales executive has left to work for a competitor, right? And so by virtue of filing a lawsuit, even before we give the judge any pieces of paper, by filing a lawsuit, we announce to the world that has occurred.
That is
right?
a very good point. Okay,
so let's get practical.
Yes, we've been
please.
promising it this whole time, so
Yes.
we better get around to it. All right, so let's think about then shifting from the legal update to the practical and what to do in a world where you choose not to have competes or they're unlawful. Again, the way we think about non-competes is protecting three major buckets of your business interests: the people, right, that you have invested in, the relationships that your business has with customers, vendors, et cetera, and then the actual information, right? And we're going to talk about each one of those categories separately because there's going to be some overlap, but some tools are really distinct. And you all, we see who registered, right? We got the list. There's a wide variety here in terms of industry, size of organization, et cetera. So we're going to give you, what did we say, a menu, a buffet?
A buffet, and then you made
a buffet
yes.
of options that may or may not fit your specific nutritional needs. That was awful. We can edit that out.
It's going to be food for thought.
No,
Sorry.
I'm just hungry.
Okay.
All right, Sarah, can you start us off with people?
Yeah, when we say the word people, what we mean is this. Sometimes we have people working for us, and we have invested in their training and development in such a significant way that we just don't want them to leave, right? We put in potentially years. And it's not so much that we're particularly concerned about where they're going or what they might take, but we want them to stay. We've invested in them. The best example I can think of, quite frankly, is Miller Johnson.
Good one.
right?
Something we know something about.
When we hire brand new lawyers out of law school, it probably isn't a secret to any of you, they actually don't know anything about practicing law. Sorry. I'm sorry, it's just true, right?
Please don't tell, you're going to go to another breakout session, there's going to be a newer associate probably.
Please don't tell them
Do
we
not
said this.
repeat.
Yes.
This just stays amongst us, amongst
They're
our
just
friend group.
earlier in their careers. Anyway, they actually don't know anything. And so we as a law firm invest, other busy attorneys who are later in their careers
More mature.
invest a tremendous amount of time that we don't bill to clients, right? In helping them learn and in helping them become great lawyers. People did it for me and people did it for Rebecca, et cetera. So that is of tremendous value to Miller Johnson. It's our commodity. Our people are our commodity and we invest in them. So that is one example of what we mean by people alone for many businesses are a significant competitive business interest.
Right.
And so if we can't use the easy button to keep our people from leaving, what other tools are out there?
Okay, so I'm going to go over a few low-hanging fruit, and you're going to say I really didn't need to come to hear a lawyer speak for these ideas, but I'm throwing them out there anyway, because I find sometimes things I should know, right, I forget after a few years. So PTO, flex time, right, things like that that make you a better place to work than your competitors, right? Everyone is about lifestyle right now and balancing, especially millennials. Stay bonuses, seniority bonuses, right? We pay people to stay with us longer. Money talks, right? As we know, these are things you probably would have thought about, but people are thinking about them. So let's talk about a few things that might not have been top of mind. First of all, sorry, my reading glasses, I've aged. Think about why people would leave to go to a competitor and nip it in the bud. And by that, I'm not talking about PTO, flex time, remote work. I'm talking about, especially because we saw lots of sales, right? Lots and lots of sales. How are they paid? Based on performance, commissions. If we make it harder for them to find success at a competitor, they will be less likely to leave, right? Assuming all the lifestyle, location, all of that stuff is in place, people leave for more money. Money is based on success. So how do we make it so they are less likely to be successful when they go to a competitor? You all probably have lots of ideas based on your own industries, but a few ideas, and this also goes to protecting our relationships, which Sarah's going to talk about in a few minutes, but layering, right? Making sure that each important client or customer has multiple contacts at your organization. So when that person is doing the calculation, if I leave, will my clients follow me, right? Oh no, they work with me, but they actually call Sarah just as much. And I know they really like her too. I actually don't know. That's a toss-up, right? The more you put in the toss-up category, the less likely they are to believe, right, that they're going to be successful at their next location. Non-solicitation agreements, which again we're going to get to. But it's not just about having the non-solicit agreement. It's about making sure the person knows they have a non-solicit agreement. If they signed it 25 years ago, and honest to God, do not remember, do not know the specifics, they may think they're going to go across the street and call all of your clients and be able to do that, right? So it's about the tools we're going to describe, but also making sure they know about them. Lastly, think about creating a culture where your proprietary information is widely known to be confidential within your organization. That was a horrible way to put it. Widely known within your organization what is confidential and what is not, but the confidential information is not widely known. And I'm going to talk about this in the third segment here regarding protecting your information, and I'm going to talk about why it's important to literally stamp things confidential. This is another reason in this section to do that.
Yeah.
If someone thinks the customer list is going with them and it's got confidential watermark all over it, they're going to think again, right? You can't stop everyone from doing bad things, but it will cause them to pause. Okay, so that is one
I want to go back
strategy.
and follow up on a few things, because that's what I do. You mentioned, because I think there is a tremendous opportunity. When you guys all told us with whom you have non-competes, two types of employees jumped out, sales and execs. There is opportunity here to structure executive compensation in particular in a way to incentivize people to stay. The most common way to do that is something called deferred comp.
Yep.
It's money that they get only if what?
If they don't
stay.
They stay.
They stay.
Or
okay?
maybe even not compete after they leave.
Yeah, so that's exactly right. So compensation, in my mind, if we're talking about executives, and even if we're talking about sales employees, compensation, and I'm not talking about paying them more money, I'm talking about how you structure their compensation can be almost as powerful a tool as having them sign a piece of paper that has a non-compete. I would argue even more powerful.
I agree.
So we're going to be much more intentional about how we compensate our executive employees. I think we're going to be seeing deferred comp is just a standard with all executives. And interestingly, on that note, even among the FTC rules and state laws, there is potentially an opening to have an enforceable non-compete that is tied to deferred comp. So you can get both. You can get the practical incentive to stay, and potentially you could structure the non-compete so that you have an enforceable, or structure, I'm sorry, the deferred comp, so you have an enforceable non-compete on the way out the door. How do you do that? They don't sign the non-compete until after they're no longer your worker.
Right.
So they have a deferred comp benefit. They know what it is. They're earning it throughout their employment, but our plan, policy, agreement, whatever it is, says in order to get the money, they have to sign a non-compete after their employment ends. They're no longer our employee. They're no longer our worker. It's not a non-compete that's tied to employment in any way. It's something they're getting simply because we're giving them money in return. There's an argument there to be made.
Right.
So I just wanted to follow up on that.
Yeah, no, I think that's a great idea, and this is something I'll add, that if this is of interest to you, this is something obviously to talk to legal counsel about, right? Because this is a very nuanced area, but we have lots of clients that are using deferred comp. It can be, by the way, one-offs. You don't have to have a whole policy or benefit plan. It can be something that's offered in an employment contract just for your CEO, for instance, or something like that.
That is all for part 1 of the Off the Clock episode at the Miller Johnson Employment Seminar. Our next episode will have the rest of the discussion. Thanks for watching.